Greetings, lecture number 3, Electronic Justice in the Countries of the European Union on the example of Germany and France. This lecture is dedicated to the study of e-justice in Germany and France. We will consider legal regulation as well as analyze examples of the transition of the judicial systems of Germany and France to electronic forms, as well as evaluate the challenges and effectiveness of digitalization in the judicial system. So, in recent years, the European Union has been actively promoting the digitalization of justice, which is reflected in the adoption of a number of directives and regulations aimed at introducing electronic forms of legal proceedings. One of the key documents in this area is Regulation European Union 2018-1724, which establishes uniform standards for the provision of administrative services in digital format. This regulation contributes to the unification of approaches to electronic justice among European Union member states, providing more effective and accessible justice for citizens. The implementation of these regulations in the national legislation of the European Union member states varies depending on the level of readiness and technical equipment of each country. For example, Germany and France have already made significant progress in integrating electronic systems into litigation, which allows for faster case processing and lower administrative costs. We will talk about this later. The legal regulation of e-justice in the European Union is a complex and multifaceted process that requires coordination of efforts at the level of all European Union countries. The introduction of electronic forms of legal proceedings contributes not only to improving the efficiency of the judicial system, but also to strengthening the confidence of European Union citizens in justice, which is an important step toward the development of European democracy. So, in Germany in 2001, the first electronic document management appeared, allowing the exchange of documents between all participants in the process. 20 years have passed, and since the 1st of January 2022, for lawyers, authorities and legal entities, the exchange on procedural documents with the courts in Germany is possible only in electronic form. Paper claims and complaints are no longer accepted, with rare exceptions. The German Civil Procedure Code, adopted in 1887, contains codified norms on the digitalization of civil procedure. Consider its key paragraphs. You can see them on the slide of the presentation. The most important tool for the functioning of e-justice in Germany is the electronic court and administrative mailbox. This is a special protected email of a lawyer through which lawyers are required to interact with the courts. Access is strictly by qualified electronic signature lawyer card. Data transmission is encrypted and meets high security standards. To use this system, the user needs to install a special program, Electronic Court and Administrative Mailbox, on computer. The program is free and available for installation on official website. The program was the result of successful administrative reform and promotes the implementation of new provisions of German legislation on e-justice. In accordance with German law, scientific and technical means of communication must ensure the efficient flow of legal information between the population and the state apparatus. The electronic court and administrative mailbox provides users with such opportunities as round-the-clock access to information court resources, reliable data transfer, secure communication using cryptographic mechanisms, the ability to electronically process files, receive automatic notifications by email, and support for all accredited signature cards. In practice, the electronic legal and administrative mailbox system in Germany works as follows. First, filing claims, complaints and applications is carried out online directly to the court. Secondly, court decisions are also sent to the parties through electronic boxes. Meeting minutes may be digitally recorded and stored. Fourthly, participants in the process have access to the case in electronic format, which speeds up communication. The websites of the courts of Germany have all the necessary information that helps the user to familiarize themselves with the rules of legal proceedings in each of them. Court decisions are also published on official websites and are available to a wide range. It's important to note that Germany practicing electronic legal resources aims, first of all, to make justice accessible to the entire population and to every person. It's important. For example, on the website of courts and other legal sites, the information provided is set out not in a complex legal language, but in a simple, accessible language. An analysis of e-justice services in Germany concludes that its main achievement is electronic document management. Germany also pays special attention to the issue of ensuring safe and confidential document management. Reforms in the field of e-justice in Germany have the priority goal of introducing additional security protocols into it and don't imply saturation with the new electronic justice services widely used in a number of other countries. Consider digital platforms, the practice of filing electronic documents by lawyers, and behavioral norms for judges in France. Over the past decade, France has carried out a reform of the digital transformation of justice. Open data of court decisions, mandatory and voluntary electronic channels for different jurisdictions, regulation of the interaction of professional participants, its lawyers, administrations, with the courts. For professional participants, administrations, lawyers, electronic exchange of administrative cases is carried out through a special portal and the EBA web interface. There is a separate portal for citizens. Portals provide filing, document exchange, notification, and case status tracking. In 2025, integration with the EBA web interface of law firms was implemented. How do lawyers file documents and how do judges work with digital? For administrative cases, lawyers submit documents through the special portal telecourses. The system assigns a number and generates a confirmation receipt. To comply with the submission of procedural documents, the date of electronic deposit recorded by the system is relevant. In civil commercial cases, attorney can also file procedural acts. Its declaration of appeal, written explanations, evidence, based on GPC electronic exchange rules. In this case, confirmations and notifications are delivered to the mailbox of the system, and the lawyer is notified of this. It's important to understand here that electronic communication and electronic filing don't negate procedural requirements for appearance and form, unless otherwise expressly provided by French law. Consider the two main documents governing the digitalization of law suites in France. There are French Code of Civil Procedure 1876 and French Code of Judicial Procedure 1878. Digitalization in the French Civil Code relies on fundamental principles from the Civil Code, Code Civil, which equate electronic documents and signatures with their paper counterparts, provided that the criteria for identification, integrity, and immutability are met. However, the French Civil Procedure Code adapts this for procedural contexts, emphasizing practical implementation in court conditions for specific court cases. For example, electronic acts are seen as the equivalents of traditional ones. Allowing systems such as the IBA platform, a virtual network connecting lawyers and courts, to facilitate electronic filing, document exchange, and the case tracking. This system was first launched in 2003 in Paris and implemented nationally in 2005. So the French Code of Civil Procedure has gradually integrated digital tools to modernize civil justice, focusing on electronic communications as a fundamental element. Introduced by Decree number 2005-1678 of 28 of December 2005, establishes rules for electronic dispatch, notifications and acts, emphasizing consent, safety, and reliability. Consider specific article. You can see them on the slide of the presentation. And so the French Judicial Code of 1978 is a codified law that establishes how civil and criminal courts are structured and function in France. The court doesn't regulate independent administrative courts. They have their own code and doesn't replace procedural rules. They are established by the Court of Civil Procedure and the Court of Criminal Procedure of France. The French Judicial Code defines the skeleton of the judicial system and its services. What exactly it regulates? Structure and levels of courts of judicial order, their territorial organization, names and locations. Composition of judicial boards and form of work of chambers, departments. Work of offices, basis standards of publicity of meetings. Separate digital provisions, for example, the possibility of holding meetings via audiovisual communication, conditions and restrictions on the electronic publications of courts' decisions. Distribution of managerial powers of the presidents of the courts and the first presidents of appeals, as well as the French Court of Cassation, is matters of organization of work. In general, it should be said that in France there is no single one digital platform dedicated to justice and legal proceedings. There are several platforms. For example, the Tribunal Digital Platform, launched in 2019, is only for commercial disputes. There is also a justice. There is also a Justice Point FR platform for family disputes, allowing citizens to initiate processes online with Safe Online. The French model demonstrates the so-called dynamic equilibrium. On the one hand, large-scale digitalization of open data channels and systems increases access to justice, reduces transaction costs and maintains predictability of procedures, receipt, timestamps, notifications. All this is transparent and visible to judges and participants in the trial. On the other hand, the French legislator creates tough barriers for algorithms that can affect judicial individualization and independence. So we reviewed the legislation and some process of digitalization of justice in Germany and France. It can be concluded Germany and France are examples of countries where the digitalization of law suites has achieved significant success over the past few years. However, there are no leading countries in the field of digitalization. The leaders in this area are the United States, China, and Estonia. In Germany, the introduction of electronic systems made it possible to optimize the process of filing and processing documents, which significantly reduced the time for consideration of cases. France also actively uses electronic platforms for interaction between the courts and participants in the process, which contributes to increasing the transparency and accessibility of justice. There are no robot justices in France yet. As of 2026, auxiliary automation is permissible, which guaranteed judicial independence and procedural rights of the parties. In France, there is a combined model, the active introduction of digital channels and open data with normativity, fixed barriers to individualizing predictive analytics system.